Please, Your Lordship. Lordship has posed a query as to whether Your Lordship has taken this matter or not.
Before that, another thing has come to the mind of this court.
Yes, my Lord.
Now, you said that the appellate authority in district council
Yes, my Lord.
had a hand in this matter. So, they played some role as a presiding officer.
Yes, my Lord. So for
But
us,
in this matter, it's a previous round of litigation.
that is TS 1990.
So why there is no question of themselves refusing it now?
Because the suit lands the
See,
same.
there
my Lord.
cannot be a conflict of interest here. So that is definitely you have a right to file an appeal with that court. If they refuse, then only you can come.
Because it's the same Sulan, my Lord.
Can be, but then it's a separate cause of action. Just because a judge had played some role on a subject matter doesn't mean that he cannot see subsequently play on a different cause of action.
My Lord. Then if my Lord can pass a
You,
direction.
no, we will not pass any order. You file an appeal there and then we will see. This court initially was under impression that the appellate authority played a role in this case, but then
No. This case is a fresh case, 2024.
then what is the problem? There is no problem. It is only your mere assumption that they will not take up.
Because the entire thing revolves around the deed of settlement that we arrive at in that the previous suit.
That is all right, but then that is the different cause of action. Now it's a different cause of action. You convince that court. That is your rule.
If some observation can come to that end,
What observation?
I withdraw the liberty to approach them since they have not had a hand in this matter. Some kind of that sort.
No. That liberty is always there. Nobody has curtailed you. Nobody has prevented you from filing an appeal. If I prefer appeal.
Because the first obstacle that we'll face is that.
Anyway. Mr. Jashillah, Lanak Counsel applying for the petitioner. It is submitted by the Lanak Counsel that the petitioner is compelled to approach this court by filing this revision. In spite of the fact of availability of appellate forum, due to the reason that the appellate authorities of District Council Court.
Yes, my lord. That is the judge.
Had played some role in the previous round of litigation between the parties over the same subject matter.
In particular, TS number 3 of 1990, my lord. Yes.
Stop. However, he submits that the present matter has arisen on a different cause of action, which was not there at the time when the previous round of litigation was handled by the said authorities. Paragraph. This court is of the opinion that just because the appellate authorities of the district council had played some role in the previous round of dispute between the parties, comma, there be any legal bar for them to entertain the present matter which has arisen on the basis of a fresh cause of action. But then, will it be proper for this court? You see, it is something there. See, like this court also doesn't want to compel them to take up the matter if they do not want, for any other reason. But then, if it is simply for the reason that they had a hand in the previous round of litigation, that cannot be a ground.
Yes,
But
my lord,
then,
my lord,
this will be too much for this court to go into all those things.
it's only on that aspect, my lord. If they have any other reason, then perhaps it's up to
No,
them.
we'll shorten this thing without going into that much detail. Just cancel the whole part. Just say this present revision application has been preferred by the petitioner before this court. But then they have not refused also on the perceived concept that the appellate authorities of the district council may not take up this matter as because they had a hand in the previous round of the litigation involving the parties herein. Stop. It is submitted by the London Council petitioner, that the present litigation as arising out of a fresh cause of action which was not there at the time when the previous round of litigation was decided by the court. Give a paragraph. This court fails to understand as to how the appellate court authorities, the district council, can be precluded from taking up this matter just because of the reason that they had played some role as presiding officer.
Yes, my lord.
In the previous round of litigation between the court. Now, what do you do?
Accordingly, my lord, this application we dispose of, that we can approach the.
Will not dispose of. You will then you'll withdraw it and file it there.
Okay. Accordingly, we'll withdraw and file it. Approach the.
In view of the above, the learned counsel for the petitioner pays for withdrawal of this petition with the liberty to approach the appellate authority in accordance with law.
Yes, my lord.
What is it? Planner counsel for the petitioner prays for withdrawal of this petition, of this revision of this petition. Yes. On prayer being made, this paragraph. This revision application stands dismissed or withdrawn with liberty as before. Actually, this court is also not supposed to make this observation. You see.
I'm grateful, my lord, because
See, this is the problem is not there. See, like this is court is concerned about the fact that it passes correct code.
yes, my lord.
We can understand your difficulty.
Yes, my lord. Our situation is such, my lord, that we are not really inclined of bypassing any authority, my lord, but because of this unique circumstances that arose, that's why we are compelled.
No, if there remains any other difficulty for the court there, then we will see.
Yes, my lord.
Just say after that it is made clear that in the event of filing of any appeal by the petitioner herein before the appellate authority, the appellate authority will be at liberty to take a call as to whether there is a bar for the said authority to take up the matter or not and pass appropriate order.
Other than the fact that they have taken,
that we have said of the other
yes,
things. We said in the event you prefer an appeal, the appellate authority will be at liberty to pass an order as to whether they can. What you said? Last line, just say. In the event. There is a legal bar.
If there's any other
Or not.
any
or
other
not. The passage order just this part is not there. Okay.
in any other legal bar, my lord, so that any other legal bar.
That is what we said. We legal bar. And pass appropriate order is not needed, because then in such a case if they take up also they will have to pass an order, so that will not be needed. So before entertaining the appeal.
Any other legal bar, my lord, perhaps that might be appropriate word, my lord. Any other legal bar, my lord.
Any other legal bar? What is the other legal bar?
Because
any legal bar, that is good enough.
Okay.
What is the other legal bar?
No, because
we do not know what is the bar. Then you say about the other bar. First, let us know the main bar. Then we'll come to the other bar.
Okay, my lord. Grateful.
See, this court is basically not.
Yes,
required just to make your cause easier. You said that there is urgency in the matter.
Yes, my lord. Yes, my lord.
But then that is otherwise not a proper answer.
I'm grateful, my lord, for accommodating us.
You have a decision for this thing. You brought a decision to convince the court.
My lord, it's only extraordinary circumstances the court can take up.
So what is that extraordinary circumstance? That is only on your presumption.
Yes, my lord. Any, my lord.
Hope this order helps you.
Yes, my lord. Yes, my lord. Grateful.
Make the appellate authority understand.
Yes, my lord.
Because otherwise they do not have any personal interest in the matter, isn't it?
No, my lord. No.
Nobody has played role as a lawyer or advocate, isn't it?
It's just as presiding
officer.
officer.
If they have handled the merely as judicial officer, there should not be bar. Then if you say that, then there will be many matters this court cannot take up.
Yes, my lord.
Because on the subject matter involving many departments, we handle many matters. But then when similar matters are coming on a fresh cause of action, we are entertaining it. There is no bar.
Yes. I think that's the correct proposition of law. Obliged, my lord.